Hello, hello. Today we're going to be talking about why estate planning matters. My name's Austin Bransgrove, part of the team here at Rethink Wealth, and our team is on a mission. Our objective, our mission is to inspire and coach families on the truths of wealth building and design a plan that supports their purpose. Our purpose is to empower families to experience purpose, freedom, and abundance. Today, I'm going to be talking through. My name's Austin Bransgrove. I'm one of the managing directors here at Rethink Wealth. I love getting to talk about this. It really ties in with so much of the focus of my practice, my career, certified financial planner, accredited estate planner. And as we talk today, you're going to see a handful of times where this QR code that you see on the screen right now pops up in front of you. That QR code is a link directly to one of the tools that we provide that'll give you a complimentary estate health check. So you'll be able to input some basic information about yourself and your family through our secure portal, and then go through to see kind of where does that look, any warning signs, anything that's fantastic, anything that may show up and you need some attention to. So as we go through, I'll pull this up a few times as we talk today. Please feel free, pull out your phone or take a screenshot, and then you can use that QR code to go through and access the complimentary estate health check. Estate planning is one of those topics that we actually get a lot of questions about. We started to develop here at Rethink Wealth this path of supporting clients specifically around some estate planning questions because we identified that it came up over and over and over in the broader comprehensive financial planning conversations we had with clients. It's always one of the areas that we've reviewed as a matter of our comprehensive planning. And I find that many individuals, many families we talk to don't have a lot of clarity about what the estate planning documents really do, how they work, what they're for. And the goal of our discussion today is to equip you with some basic knowledge so you get to start to see what is it, what matters. Estate planning, if you define it in one sentence, is really about getting what you have to who you want when you want. It's getting the right stuff to the right people at the right time in the right way. And as that's done, you can go through and protect your loved ones, protect your assets, minimize estate taxes or transfer taxes, both on the federal level and the state level. There's several states across the country that impose estate tax or inheritance tax. Critical for families with young children is that you can go through and select guardians to care for your kids. This was one of the toughest decisions that my wife and I had as we went through and we've done our estate planning documents. Healthcare, financial wishes, and then, what about decisions for your adult children? So let me give just a couple of examples in each of these categories. We'll dive into a bit more detail in each of these 6 areas that you see on the screen. And then we're going to go through some examples of case studies and what has happened to people that may be pitfalls you're not aware of. Okay. So protecting your loved ones. I was inspired to get into my profession, supporting folks with financial planning and estate planning because of very personal experience I had with this category right here. When I was 22, we lost my dad. He was 49 years old. And I had no idea what was going to happen. My mom had no idea. My younger brother was a freshman in college at the time. He had no idea. And all I knew at the age of 22, 6 months out of college, was that I felt responsible for making sure that my mom didn't lose her house and my brother didn't drop out of college. And when we began to pull out all of the documents with the beneficiary designations, the account statements, life insurance policies, wills, the way that all of that occurred really ended up being life-changing. It had the potential to be terrible. I was terrified that it was going to be even worse than just the terrible fact that I lost my dad when he was so young. And that unknown is a really big stress for so many families. I think anytime you see people posting online that they need a GoFundMe or that they're trying to figure out and they've got stuff stuck in court. Um, we see certain states with that we operate in, clients around the country, they have really, really long probate processes. And we've had clients wait years, 2, 3 years for all of the assets to flow through the will and come out of probate. And situations like this not only add to the kind of reignited grief every time you're going through the logistics of them, but they can be incredibly financially costly as well. Those probate processes, assets are not released until the probate is complete. And so the longer it goes, the more expensive it is, the more it can take up of your assets. And also, your family, who may need some of the resources and assets you leave behind, they may not actually have what you've intended to leave for them. So the way that these um, assets pass at death can be incredibly important. That's one of the things we look at on a regular basis for our clients. Some of how assets pass can also involve protecting assets. I think about myself with my family, my wife, and we've got 2 kids who are both in elementary school at the moment. And if my wife and I died today, because of some of the estate planning we do, my kids would inherit millions of dollars. And at their age, I don't know what kind of people my children are going to be. I don't know if they're going to have an accident along the way as they're in their teens or 20s and be unable to manage money. I don't know if they're going to face influence or attack from someone who may try to take advantage of them. And so the way that assets can be protected for the people that we love can be really critical to making sure that your stuff, your financial resources go to the people that you want in that right way. Estate tax, we're going to talk a little bit more about here in a moment. What I'll say is this, that on the state level and the federal level, there are certain exemptions for how much financial wealth can be passed to other individuals without incurring tax. And those figures are different based on who the relationship. A lot of times it's different if one spouse leaves funds to another, but it can be different with a parent and a child. It can be different from a parent to a sibling, an individual to a sibling. Those differences often can come up. Just the other day, we were looking at a situation for a client in a state that has an estate tax. This is a relatively young person. They've got 3 kids at home. And unbeknownst to them, because they own some real estate, they own a business, they own their home, that if the parents passed away today, God forbid, but if they did, there would be nearly $1 million of tax before the children inherited anything. And so often estate tax is called the most optional tax in America, and there's ways of going through to minimize the impact of those taxes. Guardian appointment, critically important. It is our obligation as parents to state and elect who we want to specify as guardian for our minor kids. It's a very prudent thing to go through and make healthcare wishes and advance directives so that our family is not left wondering what do we want or what should happen if something happens to us. Time doesn't permit for us today, but there's a very, very interesting and terrible story from many years ago about a lady named Terry Schiavo. And she was a newlywed with her husband. She had a terrible accident. She ended up essentially in a coma, brain dead, on life support. And there was a fight back and forth between her new husband and her parents that took a very long time, where each of them was arguing that they should have the right to make healthcare decisions for her. And all of that was a question because as newlyweds, they hadn't gotten around to doing their estate plan documents yet. Terrible situation, adds grief upon grief. And then lastly, we see this on a regular basis as we have the bittersweet day that adults send their children to college. right? So parents send their adult children to college. The moment your child turns 18, you no longer have a right to do anything for them from a legal basis. You don't have the right to go through and make financial decisions on their behalf. You don't have a right to their health records, their medical records. And so having these documents drafted, even for your adult children, is a matter of protection for them as they're still getting their, I'll say, sea legs in terms of how do you go through and operate in this life. So, the question is, what happens if you don't have a plan, or what happens if your plan is out of date? What do I mean by out of date? Well, one thing that can happen is your estate gets stuck in probate. We see this happen more often than you might think, where a lot of individuals they come into conversations with us thinking, man, all I need is a will. And a will is certainly one of the things that essentially every adult should have. The challenge is those wills end up, anything that flows through your will is going to go through the probate process. Probate is quite literally a matter of you suing yourself. In reality, it's your executor suing your estate to go through and pass assets according to the terms of your last will and testament. It can be, depending on which state you live in, long and costly. Commonly, the minimum kind of cost to go through and take care of a probate process can be 1% to 2% of the assets that go through the will. One of the most effective things to go through and put in place is to use some types of different trust structures. And there's different ways it can work. So we'll not give too much advice here on the webinar for a lot of people, for hundreds of thousands of people that are going to see this. But those wills take time. And there's a matter of going through with the court record and what happens. Sometimes we'll get the question of, well, what happens if there's a trust that comes from the will? Well, it doesn't really change anything here. That still goes through probate. Often we'll see that kind of trust. It's called a testamentary trust. You may want to write that down. That testamentary trust is drafted in the will as a means to go through and put that in place instead of creating a trust while you're alive. The downside to that is that the will, along with any trust that is born from it, remains subject to court oversight for as long as the trust lasts. So you can end up with these legal issues related to assets going through probate. You end up with these cost issues with assets going through probate. One of the most unfortunate kind of impacts of having to go through the probate process is also the fact that probate is typically a matter of public court record. And so you may be familiar, you read kind of magazines that cover what happens with different celebrities. If celebrity magazines are covering that somebody had this asset and this asset and this asset when they passed away, that's a pretty good sign that all of their wealth, or at least that portion of their wealth, it all went through a will. And so they didn't get the privacy that they may have wanted or preferred. Trusts, in most situations, are able to create that privacy at the same time. The second thing that can happen from poor estate planning is you can end up with the wrong beneficiaries or allocations that you didn't intend. I've seen this a handful of times where someone went through and they listed one of their 3 children as beneficiary to an account with the assumption that that one child would then distribute the rest of the money to their siblings. The challenge with that is that depending on the type of the account, your one beneficiary child, they may incur income tax that is unfairly allocated to them. It may be so much wealth with this expectation that they give it to their siblings that now your child incurs gift taxes or has to file for reporting for these assets that you really meant to leave to all 3 children, but you only left to one. I've even seen situations where adults with children had listed their deceased parents as beneficiaries on retirement accounts or life insurance policies. There was a terrible situation we saw a couple of years ago where a couple had accidentally out of a drafting error from their attorney. They had accidentally disinherited both of their children from an estate that was a very, very large estate, well in excess of $50 million. And so you end up with these things that happen with out-of-date plans. Lastly, here on this slide is you can have outdated fiduciaries. What does that mean? Well, it looks like you've named a guardian for your child that's your parent, but your parent passed away. Or that you name someone who's going to be your decision maker if you have a medical event, but they live in a different state than you and they're not going to be around. Or that your best friend from college used to be the person who you were going to rely on as somebody who was going to help as guardian for your kids, but you had a falling out and you haven't spoken in 10 years. Legally, until that person's removed, they remain. And so it's critical to review estate plans on a regular basis. Our kind of benchmark is that at 5 years, you really need to go through and read them again. It's not necessary that they change every single time, but it's critical that you go through and review to examine whether or not they should be updated. Okay. The last thing that I'll say, and this isn't really on any of the slides, is that the landscape of estate planning is governed by a number of laws, both on the state level and the federal level, and sometimes those change. And over the course of the last 25 years, we've had a number of very meaningful changes in terms of how much someone can give, when taxes are incurred, what spouses can give to each other, the impact of annual gifts to other individuals, what the tax rates are. All of these things can and do change, even with sophisticated plans that clients will put in place sometimes. My team reviews these every single week. Often we'll see strategies that someone will have put in place that since they were created 10, 15, 20 years ago, have received numerous court challenges, and sometimes those haven't stood up to threats from the IRS. So there's a constant need to be vigilant about what is your plan, how does it work, who are the people who are involved, and does all of that work the way that you really want it to? It's why that estate health check is so critical. And I'll just pull up that QR code here one more time. If you're thinking through, man, I don't know the last time I looked at it, this is a great opportunity. Scan the QR code, take a look. What does this look like for you? Okay, we'll at least get a quick snapshot of kind of red, yellow, green. Is everything pretty well seem to be all set, or are there some things that you may want to go through and take a look at? Okay. So let's talk about this first issue, estate planning that gets you stuck in probate. And I want to look at this example of intestacy. And it's related to the probate issue, but it's actually a measure that could be even worse. And it's called intestacy. It means dying without a will. And when someone passes away, they don't have their own will that's valid and executed, then state laws dictate how assets pass. And different states will work differently. Many of them are at least based in part of this uniform probate code. It's a similarity. There's a lot of commonality across all of the states in the United States about how assets pass. And so you can see on the chart how this works. I'm not going to read every item on the chart. If you're watching this, maybe this is a spot where you take a quick picture and you can go through and review this more. But I want to give a couple of examples where this can end up being a bit of a challenge. Okay, so one would be if you have minor children. If you have minor children, then often those children may end up inheriting some of your assets even before your spouse. For example, one of the states that I practice in is in New York. And in New York, minor children inherit half of someone's assets, and the surviving spouse, inherits the other half. Well, that could be a challenge. Imagine for a moment that you own a home. Imagine for a moment that you own a large investment account that you've been saving with, or that you have bank accounts titled to you that are yours individually, all of those accounts, your spouse only gets half and your children get the other half. That can be exacerbated by poor beneficiary designations. So, for example, sometimes we'll see a life insurance policy with the beneficiary named as my estate. Well, when it's left to your estate, two things can happen there that are maybe not great. One is any creditors you have will also have a claim to all of the assets in your estate, so they get paid before your family receives any assets. The second is that if you're in one of these states like New York, where half of the money goes to the children and half of the money goes to the surviving spouse, then you end up in a scenario where you may have $1 million, $5 million, $10 million of life insurance. And as that happens, your minor children have just inherited $5 million, but minor children can't own property. And so now there's court oversight on half of the value of your estate, and your surviving spouse may not have enough assets to continue the standard of living that your family experiences today. Intestacy for anyone with assets or anyone, especially with children, should be avoided if possible at all costs. Okay. Having a will is a far sight better than having nothing at all. And it helps. Okay. But again, maybe a will is not the be all end all. Perhaps some kind of a trust plus a pour over will is what would make sense. Let's look at a case study. So I mentioned some outdated and unintentional beneficiary designations. Let's look at this. So there was a case that actually ended up in court. This couple, David and Donna Ray Egelhoff, were unhappily married. It happens. 40 to 50% of marriages do end in divorce. And they decided to get a divorce. 2 months after that divorce was finalized, David unfortunately and tragically passed away in a car crash, and he left behind a life insurance policy and a pension plan. Although David had 2 children from a previous marriage, not to Donna Ray, he had failed to designate those children as beneficiaries after his divorce of Donna Ray. And remember, Donna Ray is not his children's mother. And so, despite suing for the money, the children lost the case. And so all of David's assets, his pension plan and his life insurance policy, which passed by beneficiary, went to his ex-wife, and David's children were left with nothing except attorney fees. Again, think about what can someone help with? One of the ways that our team helps people regularly with this is reviewing beneficiary designations, discussing your goals. What do you want to have happen? And then we can coordinate many accounts, bank accounts, investment accounts, retirement accounts, life insurance policies. Almost all of these types of assets can have beneficiary designations that will allow someone to make sure and ensure that their financial wealth passes to the correct people that they love and care for and want to make sure. Okay. So again, that QR code, take a moment, pull that up. We'd love to help you as you go through that complimentary health estate health check. Let's look at a second case study together. And I've mentioned a handful of times, well, what about probate? What about intestacy? What about only having a will even? Often, as someone acquires assets, especially if you have real estate, especially if you have young children, especially if you have assets in more than one state, some kind of trust can be amazingly helpful. And it's imperative that you actually use the trust. Just 2 days ago, I was reviewing an estate plan for a client. They recently moved to a different state. They own property in 2 different states. And their estate plan includes a revocable living trust. Pretty common, especially as one of those core recommendations as people build up assets. Their trust has no assets in it whatsoever. The attorney's note specifically recommended to the client to put life insurance beneficiary designations to be to the trust, to consider real estate title moving to the trust, especially for their state that they don't live in anymore, but they still own real estate in. That property should be in the trust because otherwise, if all someone has is a will and the trust doesn't have any assets, not only will the family have to file probate in one state, they'll have to file probate in two different states in order to make sure all of that works. The family additionally has some other businesses and ownership of other accounts that have beneficiary designations. None of those were transferred to the trust in ways that were totally possible. And so, just like you see here on the screen, having a trust is great. But if it is not funded, the trust is like an empty box under the tree at Christmas. It really does nothing. So it's critical to go through and think about let's use the planning that's put in place. This is one of the critical areas that our team supports people with every single week. Making sure that we review someone's assets, review their ownership, titling, and beneficiary designations, and that the documents that are generated by attorneys and signed by the clients to put their wishes in place, that they're actually used with assets. One of the other critical things that we'll do as it relates to this kind of category here is our team tracks regularly changes in estate tax policy to let you know when it's time to revisit the plan with an attorney and potentially make some changes so that you may be able to avoid a heavy tax burden that could impact your assets. Like I said, this is something that we see on a pretty regular basis. There's a number of situations with families where, unbeknownst to them, they had exposure to 7 or 8-figure estate tax bills just because they had done a great job. They built businesses, they built accounts, they built assets, they own real estate, they bought life insurance to be responsible for their children and each other. And as they have all of that, you start to climb up into these thresholds. Today, anyone with over $30 million of assets between the two spouses, including you have to add the death benefit to your accounts and your business assets, anyone over $30 million, there's a federal estate tax potentially, as the law stands today. In some states, the state estate tax threshold is as low as $1 million. So it can be really critical to go through and review what do you have. A lot of families, as they get into their 50s and 60s, they have well over $1 million of assets, really common. So what are the core documents that we see on a regular basis are needed? Number one, well, if you're taking notes, write these 4 things down. Okay, there's 4. Number one, a revocable trust. Sometimes in some states that can be a joint revocable trust, so it may need to be one for each spouse. It can be sometimes one for both spouses. That's something that we'll lean on an attorney for, and different states are going to govern that differently. The second is going to be a pour-over will. A pour-over will dumps anything that you didn't put into your trust when it's all said and done, so that the eventual state of where your assets go is correct. We want to have, as I've talked about a number of times here, we want to have as many assets as possible in your trust from the day that you're passing away by ownership or by beneficiary designation. Third, a durable power of attorney. This is really critical. There's 2 types of powers of attorney. One of them is durable, one of them is springing. A springing power of attorney only comes into existence when someone is incapacitated. And that can be an accident, that can be a medical issue, that can be as simple as someone being out of the country. That power of attorney allows someone, grants them the authority to make financial decisions and do certain powers that you elect on your behalf, okay? A springing power is often not what our clients end up selecting, with the whole mindset of, if I don't trust someone to do the right thing while I have all of my faculties, why should I trust them if I'm incapacitated? Okay, so normally durable is the way to go. That's what we find for clients that we work with. The springing power has that added step of often you have to get a judge to sign off that now it's effective because someone's incapacitated. So it's this extra step that makes things harder and harder in a rough moment, which is usually when these documents are needed. Harder is probably not better. Lastly, fourth, and I know I've kind of gone across the top and then now towards the bottom, this healthcare directive and medical power of attorney. So sometimes this will be called a medical power of attorney or a healthcare proxy. Okay. Um, it alongside an advanced care directive, kind of a DNR, some people would think of that. It provides instructions for what you want for your healthcare if you're unable to make those decisions for yourself. And it's everything from who's in charge of decision making to what do you want to have happen if God forbid you end up on life support. Knowing your wishes can be incredibly freeing for your family to be processing grief and not worried about whether or not they're doing the right thing and not fighting with each other about differences of opinion of what someone wants and what the other person wants. I've seen families go through this. It's a really important piece. Okay. Trust certifications, those always are generated by attorneys with those trusts. They help to provide the veracity while providing a lot of privacy to the specific details of your trust. And then letter of wishes can be something that you really pass along values and goals regarding what you want with the financial wealth you leave for the people that you leave behind. The impact of our lives goes on forever. We're just not around to see it the whole time. And all of these documents in concert, when done well, they can support reducing the financial stress that a family may have or the questions that can come up that hit families at times that are some of the hardest days of their life. The times where these documents are used and really put to the test are often really sad days because we've lost somebody who's really important to us. One of the things that we can do as a matter of love for the people we leave behind is to leave some certainty about what's going to happen. That's really how these simple core documents exist. Okay. So whether you have an estate tax, don't have an estate tax, have kids, don't have kids, have a business and complicated structures and all of that, or don't, we find that these simple core documents are almost always part of the key recommendations that get implemented for our clients with estate planning. I want to arm everyone with our last few minutes here with some key questions to talk through. I recognize that if you're watching this, you may be someone who works with our team at Rethink Wealth already. If that's the case, well, I'd love that you're here. We're really grateful that we get to support you with areas around financial planning and estate planning. We also recognize that a lot of you watching this now, you may be working with a different firm, or you may have never engaged with financial planners to go through and get support. And so we want to arm you with these 10 questions to go through and talk about with the team that you have, right? Whether that's us or anyone else. And if as you're going through, you find that it may be helpful to get some support from our team, I really invite you, scan that QR code that I'll bring up again here in a few more minutes. And we'd love to talk about what questions you have. We'd love to talk about what's going on and learn more about how we may be able to support you. So I'm going to run through these quickly. I'm going to encourage, take a screenshot. That way you've got these handy. First question here is, have your personal or financial circumstances changed since your last estate planning review? Some things that commonly shift is people move. Some things that change are people have additional children. Some things that change are people have a large change in assets. Maybe they've inherited assets from other family members that now are part of the overall conversation. Things that change may be just changes in career. We see that even large increases in income or what the regular expenses that a family has on a month-to-month basis, those changing in a meaningful way often mean that we need to be thinking about estate planning and survivor income and liquidity in a different way than maybe we did a few years ago when that was last reviewed. Number two, are the designated beneficiaries and fiduciaries in your documents the correct people? Are they who you want them to be? Okay. At the end of the day, all of this, it's your money, it's your life, it's your family, and it's critical that these people are the correct people for you. So, really important to go through and review those every 2 or 3 years. Third, have we ensured that beneficiary designations on retirement plans and life insurance policies are appropriate? You get married, you change jobs, divorces happen, new children are added. It's really important at any of these key life events that you go back and review. Do you need to change the beneficiary designations to ensure that your plans are carried out the way that you would want them to be? Number four, do we have updated and comprehensive documents, a will, a trust, powers of attorney, a letter of wishes that reflect what you would like to have happen, your current wishes? Um, Generally, when we look at estate planning documents, I said this a little bit earlier, but our preference is that documents don't get more than 5 years old without going through and having some updates. A lot of times, if powers of attorney are older than 3 or 4 years, we may end up with some challenges in getting financial institutions to honor those documents. So those sometimes have to be reviewed more often than the other core documents like a will or a trust that may need less frequent changes. But really important to go through and read them. And I'll add to this, have there been any changes in the law that may impact your planning since you created those documents? I regularly review documents that are 20 years old, 25 years old, and the law has changed dramatically since those were put in place. Sometimes that alone is sufficient for us to recommend that we get with an attorney to review creating some new ones. Number five, are your assets titled in a way that coordinates with the trust and aligns with your estate planning objectives? I've seen situations where people created these estate plans, they didn't fund them. I've seen situations where people with large amounts of wealth accidentally disinherited their children because of the way that the documents worked. It's really important to go through and review, does the titling match what you're trying to accomplish? Number six, have you designated guardians for your minor children in case of an emergency? There's no one who can replace you as a mom or a dad. And also, the person that you select will almost certainly be better than anyone that some court from a judge that doesn't know you puts in place. Number seven, have you prepared for your potential incapacity and medical decision making that may be needed in those events by creating an advance directive, by creating a durable, but that healthcare proxy or healthcare power of attorney? Just the last 2 weeks, there's someone who I know who was tragically in the hospital with a terrible infection. And the issues around healthcare directives became critical in that moment. The presence of documents like these is life-changing when life goes sideways and you need them. So, number eight, have you evaluated potential estate tax implications and have you taken steps to minimize them? The estate tax is optional in most situations. You can choose to go through and minimize them. Often it's far easier to eliminate exposure to future tax than it is to figure out how to create enough money to pay for tax later. Just this week, my team was looking at some documents for individuals who have a large amount of illiquid assets, real estate and some precious metals and things like that. These families had exposure to millions of dollars in tax and yet no mechanism to reduce or pay for the tax. They were going to be left in a situation where their heirs had to go through and sell the financial legacy that they wanted to leave behind just to pay the IRS. That kind of planning, usually not mandatory exposure to tax there, right? The tax is optional is what I'm trying to say. So important to go through and take a look at that. Number nine, have you considered charitable giving? This is one of the things that sometimes surprises people as it comes up, but it's a really important piece of everything that you often can be thinking about. I find, especially for families who have large amounts of wealth, that engaging in very intentional philanthropy can be one of the very best ways to teach younger generations about money, as well as to um, instill some values around gratitude and prevent against entitlement. That idea of I don't want trust fund babies is one of the most common concerns that my team hears as we engage with clients who've accumulated large amounts of wealth. A lot of that we can work through some values by engaging with all of the other people around us. Okay, so if that's important to you, definitely something you want to make sure you're considering. There is question number 9. And number 10, don't keep it a secret. Have you discussed your estate planning wishes with your family? Sometimes surprises that someone has something or doesn't have something are not ideal. I remember back to the story I told just as we started this conversation. When my father passed away, I was in New York City. I'd been out of college for 6 months, and I had no idea what was going to happen. And for the following days, I had these two simultaneous emotions that were held in tension of tremendous grief for the loss of my dad and a tremendous amount of stress and fear over what was going to happen to my family because my dad was the primary breadwinner and I didn't know. And I wonder sometimes how much better would those few days have been if the fear had been able to go away? How much better would my mom and my brother and I have been able to process our grief if we didn't also have fear of the unknown? I'm very grateful, thank God, that we were okay financially at the end of the day. Very grateful for that financial legacy that my dad left behind. But I do reflect, and often I find clients very intentionally want to go the other direction, at least to a degree, to say, hey, this is what we've put in place. When we're not here, or when we need something, or when we're older and we need help with healthcare decisions, these are how the decisions work. This is what we've decided to do. Do you have any questions? Those simple conversations can be so powerful in supporting families to do the most important things in moments that are tough, that are dictated by the estate planning conversations. And that tough thing is let's take care of our family. Let's take care of the people that we love. And it allows the focus to be there as opposed to worry about trying to figure out, oh my God, oh my gosh, what do we do? What do we do? Remember, estate planning is not a set it and forget it engagement. It's critical to review your goals regularly and to review the plan regularly and ensure that you make any modifications necessary to connect your wishes and your goals to the planning that you've put in place. The last thing that we'll share is this. I've mentioned a few times estate taxes. 16 states and Washington, D.C. have either an estate tax or an inheritance tax. Washington has a top estate tax rate of 20%. Maryland has both, okay, an estate tax and inheritance tax. And Massachusetts and Oregon have terribly low exemptions that begin at $1 million. We work with families in many of these states. If you live here, the impact of your estate planning is even more critical than otherwise because your exposure to tax will directly impact in a negative way the resources that your family has to continue to live out the goals that you have together, right? Remember, I said this earlier, the impact of our lives goes on forever. We're just not going to be around to see it. And the way that we engage with these questions around estate planning, these questions here, the way that we've solved through some of the problems, if you will, the documents that need to be created, the what ifs, those legal mechanisms that attorneys help us put in place, The way we do that often colors the experience of what happens when someone we love is no longer here. It can be a time to reflect and value and appreciate them. It can be a time that's filled with stress and anxiety alongside grief because of the fear of the unknown. The choice is yours about which you want to leave for your family. Our team's here to go through and support. I'm glad that you're able to be here with us today. Again, I want to bring up this QR code. Take a moment, scan it. We would love to go through and spend some time reviewing your complimentary estate health check with you. You'll have access to a report essentially immediately once it's complete that you'll be able to go in and see. This is what I have. We want you to have that as a complimentary resource from your time with us today. And if there's something that's coming up that shows up in that review and it's a yellow warning sign or it's a red and it's really critical, we invite you, let's have a conversation and begin to explore how might our team be able to support you with the estate planning questions that you have. Thank you for being with us today. Really grateful that you're all here. Hope you have a wonderful day. Take care.